Losing a microphone. Is it working now? It's working now. Better. Why someone texted you then?
Someone wrote on the chat, yeah.
No, so I asked them if it's working. We changed the sound settings. So
No, this is mine.
okay. What? Should be working out the sound, I think.
Yeah.
Okay, so now the question is, if the bottom line is that there are many cases that in halacha we don't need the pamphlets this week.
Oh, you don't?
No, we're going Balpeh this week. I mean, you're going Balpeh. I'm going inside, but it's more general. The question now becomes, what happens if halachically you're potter, based on the circumstances, based on what we determined, you're potter, but legally they have a claim on you. So generally speaking, we hold that even if you hold dina de malchusa dina, but when you're dealing with inyanim of two yidden with each other, and it does not, and we'll see what the circumstances are. We love dafka go with dina de malchusa dina in those types of circumstances. So, So, I'm just trying to see, is the sound working one? Okay, let's see if they say that. Okay. So, do you say dina de malchusa dina in this case? And you say, well, look, legally you're chayiv to pay, so pay me. Number one question. Number two question is, even if you say you don't say dina de malchusa dina, and you have to paskin a pichosh and mishvat, what about if you can make an insurance claim? And this opens up the whole Pandora's box of insurance claims in general. So before we get to that, let's give one akdama to dina de malchusa dina. The akdama is like this, and obviously it's a whole Indian, we could spend 4 or 5 shiurim just on that. But hayoytze lanu from dina de malchusa dina is that you only have to follow the law. The law of the dina de malchusa applies either on something which is directly nogea to the malchus. They have the right to establish laws which are nogea to the malchus, which would mean, let's say, the laws of taxes, the laws of currency. That the Rishonim already say, the Rash and the Ramban, they already said that you say dina de malchusa dina on that. So something which is directly nogea to the malchus. But the Ramah adds also something which is nogea to takanas hamedina. That they have a reason why this is good for the social betterment of their constituency. So they have a right to say, dina de malchusa dina, we want people to follow a certain, takanas hamedina, and that's why it's this way. Well, let's give an example where it's not either of those two. The best example, so why would there be a law if it's not for the betterment of the people or it's not for the betterment of the government? It's just they hold that this is a proper hanhaga, and we hold it's not. So for example, legally, if a husband dies, the wife is his inheritor, inherits everything. The wife gets the inheritance. Halachically, it goes to the children, not to the wife. Now, the fact that it goes to the legally it goes to the wife versus the children, what?
The sons, not the daughters.
Right, the sons specifically, is because not because it's takanas hamedina. It's not any better for the medina for it to go to the children or the wife or anything. It's just they hold that that's the ashrus. They understand that's the way it's supposed to be. It makes more sense. And on that we say, well, the Torah says that it makes more sense, or whatever the reasoning would be, to go to the sons. So a person does not have a right to, obviously you can maneuver things different ways, but a person would not have a right to take a estate to court and give it to the wife. It could, Rabbi Yashiv Paskin, that someone that takes an estate case to court and wins the money's gezel. And Rabbi Vadi has a similar tshuva like that also. Rabbi Vadi has a tshuva like that. Also, it's mamash gezel, because they have no right to the money. There's no dina de malchusa dina on that. Because since the dina de malchusa recognizes the rights of each person to give it out the way they want, and they didn't make the laws for the purpose of takanas hamedina, they made the laws for the purpose of what they hold is correct. We have to follow what the Torah says is correct. Okay?
Just really quickly, could you explain what the Torah's reasoning is? What goes to the...
No, I can't.
Yes, not quickly.
I definitely can't quickly. That's for sure. Our questions can add off. Maybe tonight we'll discuss
All right,
it.
yeah.
But the that's the logic of the Torah. Logic, but that's the whole the halacha of the Torah, and we have to go with that. So one could argue the same thing over here when it comes to accidents, right? Why do we hold what we hold? Because Chashiv Mishpah says like that. Why does the let's say there's the right? What was the legal? The person in back is always chayiv and legally. Because they hold that makes more sense. It's not takanas medina. Takanas medina is someone has to pay. The fact that they decided it's the back guy and we hold it's the front guy, that's not takanas medina. So therefore, if a person's mazik someone in a way that they're not chayiv al pi choshen mishpat, you don't have a right to claim that against your friend and claim it's dina de malchusa dina. Rather, you would have to litigate the case according to choshen mishpat. So based on the strict rules of dina de malchusa dina, l'chayra nezikin for the most part is not based on takanas medina. Nezikin for the most part is based on what they consider to be seichel. I'll give you another example, which is a machlekes whether it was takanas medina or it was a hashkafa thing, was rent control. There is rent control. So you have one yid renting another apartment from another yid, right? The going rate for the apartment in Manhattan is $5,000 a month. And this guy yarshed it from his great grandmother and he's paying $19.99. You know? He's paying $20 a month, whatever. And he can't get kicked out and anything like that. So does the from landlord have a right to say, look, we learned last month in the Perak HaShoyel, Perak HaMakapel, Mitzvah, Daf Yomi, you just learned it now, and it says in Daf Yomi, I'm allowed to give you 6 months notice and you could leave. And it says I can also charge you the going rate. So before Gemara, Daf Kufam Bezim with Bez and Bam Mitzvah. So I want to follow Chashiv Mishpah. And he says, no, 1 second, we're in a rent controlled apartment. You can't do that. So between two Yidden, right, all I want you to do is sign the lease, and no one cares if we both agree. So does the tenant have the right to demand that the landlord follow the rent control? Do you say dina de malchusa dina, or do you say choshen mishpat? So this was a very, very big machlokes. Reb Henkin writes it's made with takanas hamedina. And since it was made with takanas hamedina, you would have to follow it. Ramosha has an interesting. Ramosha doesn't want to say straight out what he holds. Don't speak about it directly. Ramosha says another thing in that tshuva regarding rent control. And Ramosha's tshuva is that it depends when the rule was made. If the rule was made after you rented it, then that's subject to the shaila. Is it takanas medina? Not. He doesn't say therefore what. It could be he held it's not really takanas medina. It could be just a little bit of like favoring they hold they're supposed to favor the tenant, not the landlord. Takanas medina.
Grandfather in the laws.
What?
Grandfather in the laws. Rules. I'm saying if the tenant says,
Oh, what is it? But then Ramosha says, but if the person came into the apartment after the laws were already made, then the law becomes the minhag medina, and therefore it's the minhag now because it's a well-known law, and if it's a well-known law, then when you entered into a contract or a lease with somebody, it was understood that you were agreeing to the minhag. So Moshe says it's not really totally whether or not technically you have to follow the dina de malchusa. it's totally much more of a bigger picture that the din of the machusa creates the minhag, and now you're chayiv to do it out the minhag. Okay, so now like this. Okay, so the Moshe basically said any rent control department that you started leasing now would be subject to the rent control.
We can't just do research. You can just do a strictly research and figure out when the law started and why.
You could. That's what he said.
They were saying in the
He's
research
saying, I don't know what
they
your
made.
shaila is. But he's
If you bought,
responding.
if the landlord bought the property subject to
Yeah.
rent control, he
No, I'm
knew
saying
when he
from
bought the
before,
building,
yeah.
right? He knew that's when he bought the building, was subject to that, then he can't go back after he buys it. He says, okay,
No, he's
but
talking.
you're-
He's not talking about buying it. He's talking
Yeah.
about the lease with the tenant.
Yeah.
Right, but when he bought the building,
yeah,
though,
who
it's
is
the
it?
same thing, that's where Moshe's going.
Yeah.
When he bought the building, he knew via dua that
Yeah.
that building has rent control.
Right, right.
And therefore,
But
all
what
the
happens is-
agreements with the lease, with every tenant.
I'm saying Rav Henkin said it's Takonas Amadina. Rav Moshe said he's, it depends.
But Moshe is not saying clearly it's stuck on us Medina, but Moshe is saying it doesn't matter
Because that goes more towards social
because it
welfare, not common
depends. It's money in
sense.
Medina. What?
Because it goes more towards social welfare than common sense.
Right. That's what I'm saying.
That's why Rav Henkin is saying it's more, that it's, Medina.
They hold it. It's stuck on us Medina, then, right?
But if you have an agreement, it holds by halacha anyway, right?
Yes, that's what Moshe is saying, and the agreement is subject to the minhag. Okay. So now let's take some different examples of insurance. Let's say you hire somebody. Some insurance agreements are let's first take a simple case. My insurance company is a Jewish insurance company, and I get some sort of flood in my house, and I want to file an insurance claim. Now, technically they're not chayiv to pay, choshen mishpat, but it doesn't make a difference. You enter into an agreement. So obviously, anytime you enter into an agreement with somebody, then they're chayiv to pay. So that was the agreement that you had made that you're going to kitzet asmachta or something like that. You entered into an agreement with the insurance company. They're going to cover your. This is again Eretz Yisrael when everything is Jews, So can you file a homeowner's insurance claim, and they're going to pay for hezek that they're not really chayiv for? So the answer is yeah, because you entered into that agreement, and Ramosha already said an agreement that you entered into a pidina de machusa is pashut that you have to pay. Okay, let's go into what happens if you slip and fall in someone's building. So as Rav Dov Kahn, when he was here, said, what's today's mentality? The first thing what happens when something happens to someone, what's the first thing that you think of? Who can I sue? It's not a Torah hashkafa. Who can I sue? The first thing to think about is, what did I do wrong that I deserve to get this happened to me? Not, maybe the problem's with me, not with them, but, okay, if I can't sue this guy, I'll sue this. So, Lemaisa and Choshen Mishpat, obviously, the owner of the building has no shaykhis to being chayiv on this. He didn't dig a bar, he didn't do anything. You stubbed your toe because there's whatever. So, are you allowed to file such an insurance claim against the building when really in Choshen Mishpat they're not really chayiv b'chlal? Right? So now, if there's real damage, and you have a real claim, could be it's understood. Also, one argument to say is that it's understood over here. It's understood that when you're going into my building, there's an unspoken agreement that if anything in here damages you, you're not going to lose out. Insurance, you'll be able to get reimbursed. It's a little bit of like an unspoken agreement because that's the natural. But to say it's a minhag is a little far on that. But over there, the again, it seems like that's a little more of a complicated case because he's really not chayiv to you, right? But Alpha P. It seems like the place can all go.
Rabbi, how far do you take that? Because yes, you're right, the landlord is somewhere in a different state, a different country, but his employees that maintain the building created a situation, and and they're hishluchim, and you slipped, you fell because of whatever they created in that building, whether it's the wet floor, whether there was a leak and they didn't fix it. So to say that I should be high had nothing to do with it, but there's
For example, Mishra, you would have to really get into it. Bar and bar's a high on
but
Kayla,
shluchim
and
applies by
what happens?
But shluchim applies by Choshen Mishpat.
It implies, but I'm saying it's not muchach. It's just because that situation happened, you would be chayv with Choshen Mishpat on that. Bar is not chayv on Kalim, so you ripped your suit, so they don't have to pay for that.
You won't be able to get anything on the building if you don't have insurance. You can't get a mortgage, you can't get nothing. You have to have insurance, that's everybody.
Right,
So-
right. So
it's-
understanding you have to have insurance.
it's-
Let's talk about
it's
another
law.
case first. Let's talk about another case first before that, because that is a little more complicated case. The other case that comes first is the not suing the mazik. It's the nizik himself, right? What happens? A guy's car drives into my fence. We had this case recently, right? You know about the case?
Yes.
Was
Huh?
this a real case?
What?
Real case?
Real case.
I know of that case, I know of other cases.
That someone drove into someone else's fence, and they say to the the owner of the fence, I'm so sorry, whatever, I'll fix the fence. It's it's a chain link fence, no problem. I'll fix. And the guy's like, I've been waiting for this to happen. I'm looking for a new fence for years already. I'll file an insurance claim, and I'll get it done. Now, what's going to happen when he files a homeowner's insurance claim on the fence? They're going to go and file they're going to make the driver and his insurance pay for the claim, right? So, can the 2 points? Number 1 point is, can the fact that it's going to go back now? In this case, he's chayv to pay. He is chayv to pay. But now the question is, he has to pay for the fence. But the way he wants to pay for the fence, like this. Another person says, no, I want to file my claim, and if it's going to cause you damage on that end, because your insurance, your premiums are going to go up or whatever it is, that's your problem. You can't stop me from filing my claim, by doing that. So the halacha, now, there's another point.
Settle cash settlements out of court all the time, but both of them have to agree.
They have to
The
agree.
person who's
And here he
damaged
doesn't agree.
told-
But he says, look, I'll pay you Choshen Mishpat, I only owe you, I owe you the money, I want to pay you the money. The answer to that is, there's one hand doesn't do the other. Choshen Mishpat, you owe me money. And I also have the right to make a claim. The fact that my claim is going to cause you some sort of other damage is indirect, and I'm not mechuyev for that. And the place can bring him a first raya to that. Because the Gemara says that, let's say you had an anos nachri. Anos nachri means a non-Jewish debt or whatever. He's owed money. He owes money, but he's a tough guy, and he says, if I have to pay this debt, the only way I'm going to pay this debt is by stealing money from a different Jew. Right? This guy owes Ruvain $1,000. Ruvain wants the money, so this guy tells Ruvain, "Look, I'm willing to pay you the $1,000, but I don't have the $1,000. If you demand that I pay you the $1,000, the way I'm going to get the $1,000 is by stealing it from Shimon." Is Ruvain allowed to demand that the guy pay him? It's Gemara Baba Basra. So the Gemara says he's allowed to. The fact that now the guy is going to go and hurt someone else is not his cheshbon. He doesn't have to lose out on his choiv based on the fact that is going to cause the hezek to Shimon. So therefore, the logic would apply that if I have insurance, then I have a choiv from the insurance company to cover my fence. You are now going to lose from my claim. That's not my problem, and that's true even if in Choshen Mishpat the mazik is not chayiv. Let's say the case was he's not chayiv. Let's say the case was it was his child who broke the fence. The child who broke the fence is less than bar mitzvah. He doesn't have to pay for the nesikin of his child.
Over here, he's gonna get paid what the guy owes him. He wants more, so that's, I don't know if it's a good comparison. Over there, he wants to get the $1,000 his own, so maybe he doesn't have to be. But if the guy's willing to give him the $1,000 he
Correct.
owes him,
This is
he
only
wants
true.
more.
Correct. This
So
is
maybe
only
more
true.
not.
This is only true if what he's gonna get is what he's owed.
Yeah. Over
You
here, he wants
can't-
more. He wants replacement.
What he's
of-
saying is, this is only true if they have a chayv to me. What's the geder of the insurance chayv? Right. Somehow this guy's planning on getting a whole new fence out of it. So the driver could say, look, that you have no right to claim and make that. Because I didn't do that as
The
a
reality is under the insurance, you don't always have that control. I mean, there are certain rules or agreements that if more than 25%, then we have obligated to replace your whole fence, and he has to say, no, you can't do that. You must only fix this.
Right, I think it's whatever legally, but it has to be obviously with full integrity of the reality of the story.
Right,
Yeah.
right.
So whatever he's owed, he's not mechuyev to give up. Whatever he's owed, even if it ends up being that the mazik is not chayev that much. The mazik may not be chayev that much, but whatever he's owed. Now, the question then becomes, now obviously, then from the insurance perspective, you're not allowed to get paid for the damage and then claim your insurance. Okay? But leaving that aside, let's say from the Chush Mishpah perspective, just in the lumdus, Rabbi Chanan declares this shaila. If someone has an insured item, and I'm mazik it, does that exempt the mazik from paying? Do you say that the fundamental chiyuv, the obligation to pay for nezikin, is that I caused you a loss, and if you're not getting a loss from this, I don't have to pay, because you're getting reimbursed from someone else? Or is the fundamental chiyuv for nezikin to pay for the damage, even if, and therefore I have to pay for the damage even if you're not losing from it technically? Meaning, could the person essentially in Choshen Mishpat double dip and say, look, insurance is not your cheshbon. You damaged me, pay. What I'm going to do with my friends is a separate cheshbon. So almost all the poskim hold that in Choshen Mishpat you're chayiv. Because the chiyuv is not for the loss that you generated, it's for the damage that you made. And if it's for the nezek, you have to pay regardless. Now legally, that doesn't work. So, the guy could say, whatever.
Why doesn't it work legally?
Legally, if you got reimbursed for the damage, you can't go and claim an insurance claim.
Is that Takonas Medina or is that
What?
Chayra.
Right. So therefore, no, because otherwise, no, I don't think that that's really, in our case, I don't think that the guy was saying, defense, pay me for the damage and then I'm going to double dip and get a defense anyway. I don't think that was the issue. But it's an interesting shaila.
They say, pay
And then-
me for the damage so I don't claim on my insurance, and then my insurance goes.
That's what he wanted to do. Right.
What about a case where a tenant drops a hammer and breaks a tile in a homeowner's home, but that tile is no longer available because the tile was put down a couple of years ago and tiles come in and out of style. And if you put any other tile there, it's going to be like a postage stamp in the middle of the living room. Is the tenant obligated to replace all the tile in the house? Probably not.
Under insurance, they will.
The insurance would cover it, but not the but not the tenant.
So the owner takes a loss then, because now the value of that house.
Put a chair over it.
Hair. Hey.
No, so where he's saying, he can still make his claim. He'll give me the $5 for the tile. I can still make my claim.
Right. He has to pay. He has to pay for the damage.
Right, but that certainly will go
He has to pay
against his,
He has to pay for the damage, and the other guy can make the claim.
right. Right, in that case, it certainly would do subrogation against the other person's insurance policy.
Against
He's
the
gonna
tenant's
say,
insurance policy.
Yeah.
If he has one. Yeah.
The tenant can't say, you can't take my insurance, I'm not chayiv to you that amount.
That's
Go
what we're
up,
saying.
meaning,
That's what we're saying. The
That he
same-
cannot.
Right, because especially in a tenant-landlord case where you went into an agreement, then the agreement, anytime you went into an agreement, everything's much easier. Once there's an agreement, you have a Moshe Svar that the Dina de Malchus Dina establishes the minhag of the agreement. And therefore, anytime there's an agreement between two people, if it's an employee-employer situation, or even a doctor with a malpractice situation, which we can get into. But those cases where there's agreements before are definitely much lighter, much easier to understand, because there you have Ramosha's whole svar that the Dina de Malchus creates the minhag. But the questions that are more complicated are when there is no agreement. Okay? So
the Nizik files an insurance claim. Does that count as a mechila on the hezek? Meaning,
Well, legally it is, right?
to now, I'm saying in halacha, meaning to now. So now we said that if he wants to
Sorry?
file,
No, I'm saying that's
he's
what
still
B'Chanan's
he's
saying.
still chayiv it.
That's what B'Chanan is saying, is that one thing has undo the other. Now, legally you're saying it should blind by mechila because legally I'm not allowed to come after you?
Meaning, I said no. I'd rather listen. You're gonna give me $100 to fix this chain link fence. I'd rather the fence is broken right now. I'd rather take $2,000 and get a new fence, and get a new fence from the insurance company. So, in essence, he's being mindful on the $100 from the guy.
Fine. So yeah, I mean, he's not gonna go after him on that, right? Correct. So the halacha is that I believe it will be poshut that the person is not mechuyev to give up the opportunity to claim, the chayiv that the insurance company has, because he has an agreement with the insurance company based on the fact that it's going to cause indirect damage to the mazik. Okay, now
Is there
the
unspoken?
shaila is in a straight out car accident case where, according to Chosh Mishpat, Reuben is chayiv, but legally, if you file an insurance claim, Shimon is going to be chayiv. So now, all these cases are when really Shimon is chayiv. The question is the Reuben, Reuben has his nezek, his nezek insurance. Well, we were talking about that you have the question is to claim against the mazik's insurance when the mazik's not really chayiv. So you say dina de machus dina. So the main question apparently
Mazik
is
ran into the back of the Nizik when he hit his car from behind,
let's say he hit his car from behind. So legally,
and he warned him with the brake light. But in such a case, it's not only the achrayus of the Nizik to warn him that he's going to stop, but it's also if you are riding behind somebody else, you also have an achrayus to follow a certain distance based on your speed.
right? You're
Stop.
right. It could be that in many cases they will be the same. The legal and Chosh Mishpat would end up being the same, but there are going to be cases that will be different. And in those cases, so when they're the same, so we're saying now that you are allowed to file an insurance claim, and even if it's going to end up being some sort of other grounds. But when the person is not really chayiv, okay, that's when it gets a little more complicated. Okay, now. He says like this. That he wants to say in the safer that it depends how insurance works. What's the pshat in insurance? Okay, if I have some sort of liability insurance, so if I hit someone in a car, my insurance is going to pay them. Is the pshat in the insurance it covers the damage to a third party, or is the pshat it protects the mazik from loss, so it covers what he would have to pay otherwise? In other words, is the claim is it to cover the mazik's loss, or is it to cover the nizik's loss? Right? What do you say?
Well, there's uninsured motorist insurance. exactly for if somebody damages you and they don't have
Th-
insurance.
That's you as the nizik, as the
Right.
person getting damaged. What about the mazik's insurance? What's the understanding fundamentally of that insurance?
That if he
Is it
damages you, he
to
has to
pay whatever damage I cause, so it's to cover the victims?
Depends what you purchase. Depends what you purchase. Meaning the price of the policy goes according to whether or not you're just looking for, the damage to me and how to fix my car versus the damage I cause others under, let's say, state law.
No, but it's liability. But is the idea of the liability insurance to protect the mazik from having to pay, or is it to cover the?
Well, so I'm in Florida, the statutory obligation is to protect the,
Right.
the nuisance.
So the idea
I didn't hear
of
what you said.
it's to protect the person that got damaged.
Right.
Yes.
My insurance is not to cover, because I have to pay out of pocket. This month.
It's not about you, it's about
You're not
them.
mechuyev to cover your own losses.
Right.
But the reason you have to have insurance is because you have to pay for the loss of the other person. So therefore,
It's to protect the other person.
they want a taina as far and that it's the same thing. Now that the nizik got hit by you, the nizik has a claim on your insurance because that's the deal. If you're gonna hit me, then your insurance now is chayav for my loss. So therefore, even if the mazik is not chayav al pi choshen mishpat, but the nizik now has a claim to the insurance. And since the nizik has a claim to the insurance, he's not mechuyev to give up that claim to protect the mazik. But if the lumdus would be that the pshat insurance is, look, you mazik, figure it out with the nizik. Whatever you have to pay to cover, we're covering your loss. If that would be the pshat, then the nizik wouldn't be allowed to make the claim because then he's claiming to the mazik, you pay me, and then but mazik's not mechuyev to pay him. Al pi choshen mishpat.
What about no fault insurance?
That's all those insurances are for sure you're allowed to claim because those are insurances that you have a deal with your insurance company that if something happens to me and nobody can cover it, I want you to cover it.
No, that's uninsured motorist, but
Right.
no fault is that nobody's at fault. Your insurance pays for you and his insurance pays for him.
Okay, so fine,
Whether it's his fault or your fault.
yeah, it's fine. Yeah, but so basically what would come out is that it would be a pretty rare case that you can't really file an insurance claim, essentially. That even if in Choshen Mishpat, technically one party's chayav, or let's say in Choshen Mishpat he's potter, but you have a good claim on the insurance, you would be allowed to file a claim against his insurance. Now, the place can make a big caveat over here, which is that if he's not mechuyev to pay anything, and he's going to have to end up paying because of your claim in court, so you're going to make him pay out of pocket money he's not mechuyev to pay. So if it's memela, you're allowed to do that. But the second it's not memela anymore, it could be it's a problem. And how does it become not memela? It depends how you file your claim. If your claim is against the person in court, which sometimes that's how you have to make a claim, it could be that would be a shot of the seer.
And also depends what your insurance covers. So if you're not entitled and you're trying to also get medical, you're trying to also get, comprehensive other type of claims, and his insurance doesn't cover that because he has the cheaper, then
Right.
I mean that would be the exact
Right.
empty.
Right. Or in a case where he doesn't have insurance on certain things, right? But
So you have to determine what his global responsibility is a Kosher Mishpah, and then what his insurance covers.
right. Yeah, exactly. So if he has full insurance, so you let him go after his insurance, that's what's coming out. You're allowed to go after your own insurance, you're allowed to go after his insurance, you don't have to worry about the premiums, you don't have to give up your insurance for him. And for sure, anytime there's an agreement between two people, for sure you're allowed to go after the insurance. That would be the basic principle. There's a few interesting cases where, like you said, repoing, you have to pay for medical bills. There's a lot of other parts to this that don't exist in Kosher Mishpat, and that requires further in exactly how a dayan would pass in those cases. Okay, but that's in concept of the insurance, like we said. First of all, to just follow with the principles. Let's say there's no insurance; it's just between me and another person. Then, since that's not the takanas medina, that's just what they hold the seichel. You really have to follow Choshen Mishpat. You don't follow the legal determination of who's at fault. But once there's insurance, then each party would be permitted to file their insurance claim. Okay? So we'll stop here.
That's the new safe roaders.
This is a safer.
Ruggers the other day.
Came
Came in 3 volumes.
Um,